Hey everyone, welcome back to DDJ's Inferno, the show where we talk about issues relevant to men. This is the part two of the double feature this Sunday. First part, obviously, we had Barbara for you to see, and now we're going to start the Layman's Legal Clinic with MGTOW Esquire. But before we get started, let me go ahead and take a little care of a little bit of housekeeping in case you missed the first half of the double feature. For those that don't realize it yet, I formally named my show DDJ's Inferno to pay homage to my first stream with Turd Flinging Monkey. And if you want to, you can watch that stream, DDJ's Inferno, on my YouTube channel. It's about 90 minutes long. You can kind of check that out. Also, I wanted to give another shout out to Taz the MGTOW. Taz made the new thumbnail I'm using for the DDJ's Inferno. He came up with the design and squared it away. So thank you, Taz. I really appreciate it. And then also moving forward with the stream, because sometimes the stream time changes, I'll be putting an announcement video out for every Sunday stream that will actually include the time it starts as well, because sometimes the time will change because of scheduling. And then, of course, if I'm targeted by YouTube, I know there's been a lot of MGTOW channels recently targeted by YouTube. If I get 2 strikes for whatever reason, I'll be using a backup channel. But make sure you follow me on Twitter. Make sure you follow me on Gab. Make sure you follow me on Minds.com. That way, if you're just following me on YouTube, if that YouTube channel gets locked down, like what happens if you get 2 strikes, then that's going to be a problem, and you're going to miss out on 2 weeks of content, possibly 3 weeks of content, because I'll be posting it to an alternate channel. And then, in addition, if you guys had noticed on the lower right-hand side of the screen, I am now sponsored by the Dollhouse, so go ahead and check them out. I've also put out my first sex doll video, the dollars and cents of sex dolls, where I do a cost-benefit analysis and get that squared away. And then again, for those that didn't see the first half of the stream, I'm working on new emojis for my Twitch subscribers now that you can subscribe to my channel via Twitch. Lone Wolf has been kind enough to help me out with that. So thank you, Lone Wolf, for helping me with the first ones. And we'll continue on and try to get the rest of those squared away so you guys who are subscribing have some more unique emojis. We got a feminist potato we're coming out with, and we've got a couple others. And also I'm going to be working on the cheers to get those cheers squared away, but I'm sort of a Twitch potato still, so I'm still trying to get up to speed there. And then finally, I'm working on merchandising. I'm in the process of developing some merchandising. So if there's something that you guys want to see, make sure you email me your ideas at misandry.happens@gmail.com. And again, if you also know of people who may be interested in wanting to stream with me, whether they host it or I host it, again, misandry.happens@gmail.com. And then finally, I'm in the process of setting up my Discord server. I just have a brand new Discord server for my $20 VIP patrons. And so I'm in the process of connecting it to Patreon right now. And I just want to let you guys know, kind of give you a little bit of forewarning so that when it's completely up and running, everybody has access to it. And then finally, my Q&A thought, Lily Even 32. We're gonna change the Q&A up a little bit. Again, for those that weren't on the last stream. So you can ask your questions at any time. She'll go ahead and log those questions and ask them. Now, I know there's been a little bit of confusion because she's either kind of, there's been some question of whether or not she's added some context to the questions, or that maybe she's not asked everybody's questions, like if multiple people have asked the same question. So the way that we're going to handle this, I've spoken with her about it, and here's how that's going to work. The first person who asks the question will get it answered. Anybody else who may have answered the question will just kind of identify that you've asked that question and that it's already been answered. And so we'll move from there, because I don't want to answer or ask the same question 15 times. And if you already know the question has been asked and it's been answered already, and you ask the same question, you might be a potato. So, it is what it is. And on this show, potato lives don't matter. My suggestion is, if you need to be a potato, you should watch the first stream. Go to Slovenia. They love potatoes there. So with that in mind, welcome to the second installment of the Layman's Legal Clinic with MGTOW Esquire. MGTOW Esquire, say hi to everybody.
Hey, everybody. How you doing?
All right, guys. Are you able to hear us okay? I just want to make sure that our volume is where it needs to be. I just want to double check that real quick. I'll wait in the chat and wait for some response from the chat real quick. All right, perfect. So it sounds like everything is good. I see some yeses there. All right. So today we're going to talk about evidence. Um, so we're just going to jump right in. So MGTOW Esquire, talk to me about why it's important in a general sense to like where does the whole evidence piece come into court litigation?
Well, the purpose of evidence is basically to prove assertions, claims more likely than not to have occurred. For example, in a criminal context, the fact that you've got a dead body is a piece of evidence that a crime was committed. Now, the fact that the body is dead doesn't necessarily indicate how that body came to be dead, so you need other evidence to establish this was in fact killed. And then you need more evidence to indicate the manner in which the person was killed. So you need pieces of evidence to establish the claim that this was, say, for example, a murder as opposed to an accidental overdose. Does that make sense?
It does. So like a murder as opposed to a suicide, or a murder as opposed to like, basically, oh,
Well,
they
self
ate too much paint.
self-defense, or they licked too many windows, or they licked the wrong windows. You get the
Right,
point.
right. So, and Lily, we were talking about the windows for your benefit. We get concerned.
Well, I mean, they're a legitimate issue. People need to know about curtains and
Well,
drapes.
when you run out of windows to lick, there's always Tide Pods.
Yeah, take the Tide Pod challenge. There you go. All right. So, so what kind of evidence can be discovered in the context of a court case? Let's talk about this in a family law context. So, obviously, there's a lot of guys out there that they want to make assertions. So, before we even talk about the type of evidence, let me take a step back. Can you talk about the difference between uh, relevant evidence and irrelevant evidence for the guys out there? Because some of these guys will be representing themselves, so this might give them a little bit of pointer there.
Yeah, relevant evidence. If you're asserting, say, for example, that you know, the spouse, if you're trying to assert something as complicated as my ex-spouse is crazy and she lies, uh, giving a layman's opinion, your opinion that she's out of her mind, that's emotionally relevant to you, but it's not going to even be slightly important to the judge. They're not going to care. Now, you can try to prove that by adding things to it. Well, she takes this particular cocktail of antipsychotic medication, judge. Um, she has done these things in the past. She painted herself purple and climbed up the side of a building thinking she was some form of Spider-Man. That, and if you have a video of that, or you have other witnesses to establish, yes, indeed, she did do that, or she cut me, and I've got a picture of the knife, I've got a picture of her wielding it, I've got a picture of the injury. These are all things that would be pieces of evidence. Now, the fact that you're emotionally your emotions around it, these are all very emotionally relevant and charged things. That's where there's a concept that comes in called prejudice. Relevance is always balanced by prejudice. You don't want to go into, say, for example, a criminal matter, um, and say, this guy was shot 5 times in the heart, and well, what evidence do you have? Well, here's the heart. Count the holes. That's you do that, you're really inflaming the jury or the finder of fact. That's a good example of prejudicial. You want to show a fairly clinical and detached, which will get us into another thing. When you're making assertions that are very charged, you have to be very level-headed. One of the things that the DDJ has said repeatedly is you kind of have to switch the emotions off when you're making these assertions, because if you start screaming and yelling, you've lost. I've had clients get very upset in cases, and that's a surefire way to lose your case. You have to be very calm when you explain these things to the judge, the finder of fact.
But I like to refer to it as the difference between uh, testifying and arguing. And
Exactly.
one of the things that I talk about with guys that are in court, especially guys who don't have attorneys, is when you're in motion hearing, so you're in a non-testimony hearing, because you're the party, the judge always tries to merge your argument with your testimony, and then will try to use what you say to bury you. So if you go into argument mode, in other words, all you're doing is arguing the evidence that's already filed with the court. In other words, like the declarations under penalty of perjury, the affidavits, the exhibits that are attached, the certified documents, the things that are already in the record. Those things are you want to argue those things, but you don't want to add any testimony to that or make any assertions, or else you could be considered what is that we were talking the other night, MGTOW Esquire,
Trying
statements
to
not in
add
evidence.
facts. Yeah, it's a weird concept for laymen. It's like considering. I'm not a big football fan, but the any any evidence, or rather any facts that are in evidence should be considered to be, they crossed the end zone. They are now in the goalpost. So the judge is supposed to make his decision based on what pieces of evidence are in the end zone. And he's not supposed to be looking at other things like, oh, well, he told me across the table in a motion hearing that he thought his wife was a horrible cheater, but there's no evidence here of that, so he shouldn't be factoring that in.
Right.
Or if he admits during a hearing that he cheated too, that shouldn't be in evidence. But oftentimes judges are human; they will make that mistake. So you want to watch what you say in court, even if it's not an evidence. I mean, even if it's not a testimony, you want to watch what you're saying, especially as the party. Whereas an attorney has a lot more latitude to get ideas across to the judge without, well, attorneys typically don't testify in hearings. So when they make an assertion, they're talking about evidence they have to offer.
Right. They
And
take
if
themselves out of the equation from an evidentiary standpoint.
right, it's one of the reasons why it's useful to have an attorney in these cases, because in addition to not being emotionally entangled in the case, you know, they look at things a lot more dispassionately anyway. And as a consequence, when they're offering evidence to prove up an assertion, the judge tends to take it more seriously. So if the attorney gets up there and says, "I have this evidence that she's taking numerous antipsychotics, and when you look at this list of cocktail drugs that she's taking, you can see that there are some contradictory medical indications that will produce some bizarre behavior, and I've got this evidence here that she's actually exhibiting this bizarre behavior."
Right.
I guess I'm stuck on drugs today. I don't know what my issue is. I
That's
keep
okay.
bringing
I
that kind of
understand. You
circumstance
had
up.
some whiskey the other night. That's I'm not a hater.
I had a lot of whiskey, but today it's nothing but coffee. So
Fair enough. Um, okay, so let's shift gears a little bit. All right, so we've talked a little bit about relevant evidence. We've talked a little bit about irrelevant evidence. We've talked about the potential of prejudicial evidence, and we kind of touched real briefly on the difference between argumentation as well as testifying. Um, so, from a context of motion hearing, and again, this is primarily in a family law context, let's talk about the proper ways to present evidence as far as like certifying and those types of things. You want to get into that a little bit?
sure. Well, one of the most important things you can do in evidence with evidence, say, is you want to try and produce it. This goes back to, I mean, I've heard numerous TFM streams where um, somebody talks about, well, he went out and took video of his wife with another man. That's not a good idea. That evidence would not be admissible no matter what, because number one, you were stalking her, so she's got that claim now she can make. Number two, the chain of custody for that piece of evidence is completely demolished. Just like in the beginning of any single case, the service of process cannot be accomplished by by a party to the case. It has to be produced by a neutral third party, or somebody who is disinterested in the outcome. It can be anybody over 18, and it doesn't have to be affected. There's a lot of rules about service of process, but a neutral party generating the evidence, like a private investigator, a process server, any witness who isn't loaded with bias. Having your girlfriend testifying to what your future ex-wife does isn't going to be all that useful, but it is a comparatively neutral third party. Not
Right.
wise, but it's going to go to the weight of the evidence as to how much bias is in there. But generating the evidence through a neutral party is the best way, like a witness who doesn't really have any interest in it,
Right.
in
Well,
the
and that's
outcome.
And that's something that I talk about a lot with clients, and I've said a few times on the TFM stream, is that for the guys that are out there, if you're presenting evidence, you want to present it in such a way that you don't need to be there to have the evidence carry weight. So in other words,
Very important.
you should never be the originating source of the evidence. You should always have some kind of third party evidence. It's like what MGTOW Esquire said earlier. You know, if your wife is batshit crazy, well, do you have a psych eval from her psychologist, or do you have a certified diagnosis from a therapist that says that she's not only insane, but like what the therapy plan is? If you have that, then now you have a potentially credible piece of information that you can do discovery on, that you could submit to the court. Um, but if you're the one who's going out and doing it, then you could bias the evidence and you break what's called the chain of custody. And if you don't have a valid chain of custody, that's where your evidentiary arguments break down. So,
Yeah. In the
go
worst
ahead.
case scenario, they're summarily excluded. And at a certain point, the judge gets sick and tired of you trying to bring in stuff that just isn't relevant or has a broken chain of custody, and they'll just exclude the evidence, so they'll never even hear it.
Right.
And that's some awful stuff, because your entire case can be sunk. One of the things that's important to understand in all cases, there are elements to claims. There are pieces of it. There are various parts, and it's very much like putting uh, physical items like a pen, a little cup into cubby holes, and those little items that are put into these cubby holes to establish the elements of a claim. Like, for example, I mean, the easiest ones for laymen to understand are usually criminal ones. So murder is a good example.
Mm-hmm.
You got intent to kill, murder. You have a killing of another with intent or malice aforethought. There's a whole bunch of things to it. There's elements to it. Like a contract would be an offer and acceptance and consideration, or a consideration substitute. Those are all cubbyhole slots that you have to put evidence in to establish a claim. And the weight that's given to the evidence, that's another issue too. But it's important, because the more biased or attackable a piece of evidence is, well, you took this video yourself, or your best friend took this video, or a private investigator took this video. A private investigator takes a video, that's pretty good evidence. This private investigator has no particular reason to lie. If he went out and took video and didn't catch anything, that's not even going to be something that's going to ever get entered into videos. Whereas, and he's still going to get paid regardless of whether he catches them or not.
Right.
So that's really good neutral third party type stuff. Yes, it's expensive to hire a PI, but you get my point. Um, the best evidence has the most weight and the least emotional relevance to you, the party.
Right. Yeah. I think the more the evidence ties into one of the parties, I think the more it gets challenged.
That's
Um,
correct.
let me ask you this. So let's talk about evidence, because I know that we're in an information age. Um, Talk to me about what your thoughts are about how to preserve like emails, social media, direct messages, those types of things. I mean, a lot of that stuff is now getting into. I mean, they're last 5 or 10 years, maybe even 15 years in some cases. That stuff's getting into divorce cases and it's getting into court cases. So
Oh
um,
yes,
electronic
texts and
discovery is
emails are
huge.
it is. It's enormous. There's a lot of rules surrounding e-discovery, and a lot of attorneys aren't real familiar with it. I'm just getting there with that stuff. Um, for simplicity's sake, the easiest way to do it is to have a printed copy of everything to try and bring something into evidence. But then you have to establish that that is their email. Before you have to establish that that is the actual email of the party that you're seeking to use the evidence against. So you want to bring in something that's fairly neutral and unbiased that comes from that source, and then you want to have the damning piece of evidence to prove the damning part. You want to prove that this is in fact them, and they're not going to likely admit that. So you have to be able to prove those pieces. So you want to
Right.
bring in the stuff that establishes, yes, this is them, and yes, they did say this, and yes, this is the time they said this. And if you're going to be going, a more difficult route, the best way to get it is to get sources. Like, if you're doing texts, one of the best things you can do, it's expensive, but you contact the service provider and get a printout. I mean,
Right.
you can forward screenshots and stuff, but that's not as easy to use. And again, you're getting back into courts have admitted those, but unless it's pretty clear from the paper copy of the texts what's going on and who's the party to this conversation, you're going to have a lot of hard times trying to get that in. Veiled threats and things like that, they don't really work very well. You want to
Well,
have something pretty clear.
right. And I think that one of the things too is I mean, you're talking about laying the foundation. And, this is something that is normally done in cross-examination where, if you don't have those certifications from the cell phone provider, you are asking them, Mrs. Smith, you had a conversation on the 10th with your ex. Yes, we did. How did you have that conversation? Oh, we had it via text message. Are these the text messages you had? Is this your, or, can you remember the conversation? Then she says yes. Then you introduce the text messages and say, are these the text messages? If she certifies that they are, then you can start talking about them and asking that. But I think you're right. I think that, any attorney who's worth their weight, who prepares their witnesses, is gonna have at least some defense against that. I mean, what are your thoughts?
It's true. It is, it's a lot of this evidentiary type stuff tends to wind up being a lot of artwork as opposed to clear black law. Black letter law has been on the decline for years. Uh, it was one of the reasons why I was so not so fond of generalized litigation many years ago, is because of the decline of black letter law. You wind up with judges that want to make the world a better place, and you get some pretty shitty results.
Yeah,
So while if you do follow the procedure correctly, you should get a better result than if you don't. If on direct, you go ahead and lay the foundation for the piece of evidence you're offering. If it's a good piece of evidence that's offered from a neutral source and a credible witness, you get it in. The other side can still attack it. They can say, well, this person's not really a neutral source. They were receiving a paycheck for getting this evidence. Well, well, this is a private investigator. That's what they do. They would
right.
have gotten paid whether they went out and did this work and didn't find anything, or whether they did. They still would have gotten paid. So that eliminates the bias. But that goes into the weight of a particular piece of evidence as opposed to, I mean, this is the reason this stuff is complicated. And it's also the reason why you really want an attorney. Trying to do this as a layman, the system has gotten very convoluted. As probably, I bet you 90% of the people watching this are probably getting blown away by the level of idiotic complexity of this. It is extremely
Yeah,
complicated.
exactly. I mean, it ends up being like a complete shit show most of the
It
time.
does. It does.
Um,
There's no way around it. But the proper way to do it is to follow the procedure as carefully as you can. Be dispassionate about it. Uh, lay the foundation. Build your case from the ground up. Don't don't go for a conclusory statement. You know, at the outset, because you're going to wind up really running into problems. One of the axioms attorneys are taught is extraordinary claims require extraordinary evidence. And if you don't have the extraordinary evidence to make a claim, you're not going to get anywhere with your case.
right. Can you speak up just a little bit? I notice your
Oh,
volume's
I'm
getting a little bit
sorry.
low. No, no, you're
Yeah,
good.
darn microphone.
Yeah. No, that's okay.
Something
And I'll try to
something to
run a
get better.
compressor. I'll try to run a compressor once we get done with the stream and see if I can bring your voice more equal with mine. So,
Sounds
but this
good.
way,
Sounds good.
but the people in the live audience, we're going to need you to project a little bit. Um,
I will try. I will try a little harder.
yeah, that's okay. It happens. I just don't want you to talk yourself out.
Nope.
Um, all right. So let's talk about the importance of discovery in a family law case, because it seems to be an area where a lot of attorneys miss in family law. Like they just want to write letters back and forth, go to motion hearings, and then go home. Um, do you? I mean, is that your perception as well, or are you seeing attorneys do a lot more? I mean, where you're at, do you see a lot of attorneys do more discovery?
I'm not seeing attorneys do discovery these days with the advent of no fault of force. What I'm seeing, and it's disturbing, is well, what I'm seeing is they're using the quick and dirty method of getting the case done, and then they're done. Just it's pretty much what happened to that guy that was on that stream last night. His attorney was sending out letters, and that's not a good way to proceed. Your attorney isn't doing you any favors if all they're doing is writing letters and not actually trying to get the case to to have a judge in front of you where you can argue your case. If the other side's not cooperating or even participating, they're dragging your feet while you're exhausting yourself and spending money to send letters back and forth. That
Right.
accomplishes nothing. I'm seeing an awful lot of that,
Yeah.
where the case just drags on. And now, well, the judiciary has noticed that this happens, and what they're doing is they're putting pressure on judges to start a clock on a case, and the judges will arm twist to get the cases to settle and finish up. So
Right.
while that's it's really dubious in terms of its uh, enforceability, and its ethics about it. It's just a question of, you got one side that brings in this outrageous claim, and the other side comes in and says, well, that's BS, and the thing goes round and round and round until it looks like there's going to be a conclusion, and then the one side that brings in the outrageous claim drops the case. And
Right.
there's trying to get them to stay in, unless you've got all the paperwork set, you can't. They wind up leaving, and you're screwed, and
Yeah.
you
And
just wasted a lot of money and got nothing out of it.
right. And I mean, that's kind of like, I mean, that's almost, I mean, that's sort of like what you're describing is churning the case, it sounds like.
It is, and I'm seeing it. I'm seeing a lot of that happening. It's not what I would consider ethical by any stretch,
Right.
um, but I am seeing a lot of it. Just the existence of no fault produces a lot of laziness,
Yeah, I would agree with
unwillingness
that.
to actually stick your neck out there, and you can send one letter, but if you don't get any response to the letter, you've got to move to the next step. You got to get the judge involved, file a motion, and get moving on the case. You can't just sit there and say, well, I'm waiting for them to get back to me. Well, after a month, they're not going to get back to you. They're ignoring you,
Right.
and you can't allow that to happen in a case. And there's an awful lot of people that don't do that, and they just let it go forward.
Yeah, I agree with that. So then let me ask you this. So, you get your case started, laymen are out there getting their case. Obviously, if they're a non-attorney, they can't issue a subpoena. What are the other discovery tools at the disposal of a person who doesn't have an attorney, or maybe before they're able to get an attorney, if they can't get one right away? What are the discovery tools that a layman has at their disposal?
Well, the first least expensive and most productive would be interrogatories.
All
Um,
right. Can you
in
speak
some,
up and repeat that? I'm sorry.
yes, the first least expensive and most valuable is interrogatories. They have to be answered under oath and in writing. So what you get is information that you can dig further on. So when the answers come back, yeah, it'll be loaded with all sorts of objections if it's properly handled, but you're getting to the point where you can nail them down on a few of these evidentiary issues. So then after you get the evidence back, or the responses to the interrogatories, you have information that will tell you more things about what's discoverable, what things you can find out, what witnesses there may be. So you can send interrogatories even to a non-party witness, just like you can depose a non-party witness. The next piece of, you can also um, do a request for production of documents. I'd like to see the financial statements you've got. I want to see a copy of the rent you're paying each month. I want to see who's paying these things. Um, most times financial statement of net worth, that will give you some idea, and those are standard in almost every divorce case. But discovery, interrogatories, requests for admissions, um, deposition, these are things that will nail them down, so that you don't have to prove every single part of the elements of the case. You've got their own admission of these various and sundry pieces, various and sundry pieces of the case, of the claim.
Right.
So
Well,
once you
and
nail down one part of it, you move on to the next part.
right. And I think also too that, I mean, that leads us to the next most valuable tool, which I think is requests for admissions and denials. Wouldn't you agree?
Oh, those are awesome. They're fantastic.
Let's talk about those a little bit and kind of explain that to the audience what those are.
A request for admissions is basically like a true-false questionnaire. You're saying, admit on the 23rd of September that you were at this place. Admit on the 23rd of September that you were doing this at that place. That's basically what to do. Admit that your boyfriend's been paying your rent for the last month. you want to break it down into the small bite-sized pieces so that you get a yes. Once you know the fact pattern surrounding it, you can nail it down into bite-sized pieces. Like, admit that your injury that you took a photo of wasn't me. It was actually this other thing that happened. And you find out what it is in interrogatories, and then you nail down and break it down and get an admission saying this particular claim is BS because she admitted on this date that this did not happen, or that this did happen and it didn't happen how she put it in her claims. And
Right.
you may get denials, but you have to paint a picture with words through nailing down assertions with requests for admissions. They're like, once you get an admission that says yes to something that is required for your case, that's like a silver bullet on that one issue. You don't have to prove it. It's done. It's already there. Once that's just going to go straight into evidence because it's the other side admits it and it's under penalty of perjury. So it allows you to winnow away the things you actually have to prove in a trial, the
Right.
things you have to have testimony for. You're going to wind up getting past a lot of things that might be contentious and difficult to prove. If you have them already established, you're done. You move past those and you move on to other
Yeah.
elements.
Yeah, I think that I would agree with you there. The other thing that I think that's important for people to realize too is that when you're dealing with the evidence, I think it's important to, like, let's take it from like a child support perspective. If you look at so in divorce, everybody has to file financial declarations and disclose their assets and expenses. A lot of times what'll happen is that they will disclose expenses they don't have in an effort to wrongfully reduce their assets. And
Correct.
one of the biggest ways they do that is, for example, a woman will say she's paying $1,000 a month for rent, when the reality is that she's not actually paying that. She's banging some guy. She's got a boyfriend, or she's got some sugar daddy who's paying that for her. But she's saying that she's paying it in an effort to, like, reduce her net income. And if you do the request for admissions and denials and the request for production of documents, you can get her bank statements, you can get her rental receipts, you can get a copy of her lease for her place, and you can prove all that stuff, and you can drill right down there. So I think that that's extremely important. Go ahead.
And from a tactical standpoint, if you know things that she's going to lie about, getting her to sign a request for admissions and say she didn't do something that she did do and you can still prove it from another source, that really makes a difference, because then you're basically proving a perjury. While it's unlikely the court's ever going to do anything about it, the likelihood of the judge taking any of her evidence is as credible, especially if it's her personal evidence for her side of the story, it's going to go right out the window. So
Right.
don't be disheartened if you put out discovery, you put out interrogatories, you put out requests for admissions, and they come back with a total pack of lies. The trick is you have to have other ways of getting that same evidence. If you can find them, and there's multiple ways of getting these things. You send out the interrogatories, send out the request for admissions, then you follow it up with a production of documents to try and back it up. Well, if they don't have the documents to back up what they say, or the documents that come back don't come back with evidence backing up what they said, you've got what you need. Then you can
Right.
prove up that they're lying, which is that's a pretty big thing to have.
Well,
Very
it's
important.
yeah, and I think to dovetail on that, what we're talking about for the audience, we're talking about reconciling the documents and the evidence compared to what the opposing party is saying. So let me give you an example. Let's say somebody says they have a job, they work at the Acme Corporation, and they say they're a contractor. But if you go to the Acme Corporation says, no, they're not the contractor. They're the chief operating officer at the Acme Corporation. Well, now you can show that there's a third party source that says that they're the chief operating officer, but they say they're a contractor. Now you have something that you can work with. You want to go ahead and respond to that there, MGTOW Esquire?
Yeah, no, that's exactly that's the kind of stuff you want. You want to have the evidence. A lawyer. One of the best analogies I've ever heard for a lawyer is a handgun. The client gives the bullets. So if you help your lawyer marshal those resources, marshal the evidence, and get proof for your side of the story, that is gold. That is exactly what you need. And try not to worry so much if they lie. If they give you a pack of lies when it comes back from interrogatories, just try to think of alternate ways to prove what you're saying. And don't look for, well, my mom saw her say this. Well, your mother's kind of biased. It's not going to hold a lot of weight. Look for people who are not interested in the outcome of the hearing. If you're looking for testimony, you're looking for it for people who don't have an incentive to lie.
Yeah.
Like
Right.
the employer, like heck, anything. And
Right.
anybody who's not interested is a perfect witness for the things you're trying to establish.
Now,
So
let me ask you this, and this is kind of builds on this whole idea of once you found your damning evidence. In other words, once you found your evidence of illicit conduct, or you can show that the person is not telling the truth about something. They say they're a contractor, but in reality they're a main officer of the company that they say that they're just a contractor to, for example, or
correct.
they say they're paying $1,000 a month in rent, but you can show that their bank statements don't have those deductions every month, those types of things. Now, it's been my experience that once you catch somebody in something like that, that they usually try to deflect by counterattacking with character attacks and ad hominem attacks. Is that your experience?
Oh, usually that actually, yeah, about 90% of the time. Some people just have absolutely no shame, so they're just going to dig themselves into a hole. And I've seen it. I've seen it in some of the recent cases I've had, and it gets ridiculous. But usually, what they'll try to do once they've been uncovered, once they've been revealed as the scummy liars that they are, they'll try to get out as quickly as they can. So before you spring that trap on them, make sure you have all the pieces in place so that they can't just get out of the case. You
Right.
want them locked in so they can't just leave. So make sure that if there's you got a claim, they got a claim against you, make sure you have a counterclaim. So that
Right.
so they don't get to just leave. Um, so that's key. That's very important. It's
Well, and
just,
go ahead.
yeah, I've seen it too often where they'll allege domestic violence. They'll make all sorts of claims, and when their claims start to fall apart, they're gone. They just disappear.
Exactly. And I think that that's what's important too. I think what the idea of that there's a false DV claim or a false rape claim or a false child abuse claim, these things happen a lot. So for those people that aren't used to family law, I mean, this stuff happens daily. When somebody gets caught being dishonest or somebody gets caught lying and you can actually prove it, not that you know it, but because it's not what you know, it's what you can prove that matters. That's why evidence is so important. Um, they almost always respond with some kind of counterattack or ad hominem attack, because what they're trying to do is they're trying to attack your credibility so that the court won't listen to the evidence that you have. Because if they don't attack your credibility, they know they're done. They know that their goose is cooked. Um, so if there is no evidence, then I always say just ignore it, not worry about it, handle it as it comes up, like in motion hearing or wherever it comes up. Make sure you respond to it appropriately, of course, because you don't want to get caught by a default judgment because you chose not to respond. But that you want to make sure you refocus on the evidence that you're trying to present. Make sure that you don't let them reframe it so that the court's not paying attention to you. I mean, that's kind of my thoughts. That's kind of the type of way I've moved forward. What are your thoughts on that, MGTOW Esquire? And Ian, do you have anything to add?
Well, it's tough to do trying to get sometimes the judges get their attentions drawn away by stuff that's extraneous and not relevant. Emotional evidence tends to charge. That's where prejudicial comes in. So you have to have objections for things that are just absolutely prejudicial. Claims of, well, he hit me again. Wait a minute, you just proved that you lied about the last time. So you want to just objection, foundation. There's a whole bunch of things you want to do to try and knock evidence like that out. There's a lot of tools at your disposal, but the tough part is knowing when to use them and how to use
Right.
them. And character evidence in general, evidence of prior bad acts and habits, those kind of things, they're not allowable in a lot of circumstances. Some of them they are, some of them they're not. So it's much better to have direct evidence of what you're asserting as opposed to, well, she's done this before. If you can
Speaking,
nail down, go ahead. Yeah.
I was gonna say, speaking of which, so talk to me about the difference between direct evidence and circumstantial evidence, to kind of give the audience a bit of a primer on that.
Well, circumstantial evidence would be, well, there was an awful lot of blood found around the car, but there's no body. That's a circumstance that indicates somebody left a useful amount of blood sitting behind. It indicates that a crime took place, but it doesn't actually establish what the crime was. Was it just a fist fight that had a bloody nose that went everywhere, or was it an actual murder? Um, these are all parts of it. Direct evidence is the body. That's a piece of direct evidence that something happened. Um,
Or maybe even the
direct
body covered in blood.
Even the body covered in blood. These are all pieces of direct evidence. The weapon that was used, that's direct evidence. Well, actually, that's closer to circumstantial, but I think you get my point.
Right.
Any piece that pushes a claim closer to being established as a fact is direct evidence. If it just pushes it a little bit and it could have an alternate theory propounded as to why this happened, that's when you start getting into more circumstantial evidence.
Right. I would agree with that completely. All right, so we've talked about the difference between circumstantial evidence and direct evidence. Let's talk about the theory of the best evidence rule. What are your thoughts on that?
Best evidence rule. Goodness gracious, that one sure
I,
takes me
I know
back.
I'm digging. I'm digging.
You are digging. You're digging. Well, the best evidence rule, if I remember correctly, and I forgive me for being foggy on some things. I'm a little older and I don't always deal with some of these things. Best evidence rule. That one's, well, that would be if you're offering circumstantial evidence when you've got direct evidence, don't offer that. Don't offer a testimony that something happened if you can offer a picture of what happened. Don't start arguing about negotiations if you've actually got a signed contract. You
Right.
want to use the evidence that is most on point for the thing you're trying to prove up.
Yeah, and the other thing is too is if somebody has circumstantial evidence and you have direct evidence, the court should be siding with the direct evidence over the circumstantial.
Correct.
So now earlier you talked about objecting to situations where the evidence isn't relevant. Now, one of the things that I've noticed, and I know that there was a video from Marcus a few weeks ago about a guy who was having a court fight across jurisdictions, multiple countries, and from what I gathered from the case, the party, he had an attorney, and the attorney didn't object when the objection should have happened. And I was concerned that maybe they may have waived the objection because they didn't do it right away. Can you go into the appropriate time to object and kind of talk about that a little bit?
Well, actually, I'm afraid I want to stop you there because I now remember the best evidence rule exactly, and it's
Okay.
not quite. You're
I'm
correct.
close.
Well, you're correct in the legal theory behind what you're talking about, but the best evidence rule itself is not really that kind of a rule. The best evidence rule is about documentary evidence. That's why it threw me because the best evidence rule is a contract rule. Wait a minute.
Yeah,
That means yeah, you want to use the superior piece of evidence. You're right in the way it's used as a general principle of law, but yeah, the best evidence rule itself isn't
no,
that.
it's specifically for
It's
documents. Yeah.
yeah. If you got a copy of the contract's going to prevail. Any testamentary evidence about what was actually said in the negotiations doesn't matter as much as what the contract.
Exactly.
Anyway, I'm sorry. I had to digress a little bit on
Oh
that.
no, that's fine. I would rather have you
I
do
was
that.
so foggy. I was so foggy when you brought that one up. I'm like, what the heck? It doesn't seem to. Anyway, I apologize, but yeah,
No, you're fine.
that's what that is.
All right.
So
So
now
let's talk
you had
about
asked about a video from Marcus. Yes.
objections, timeliness of objections. Talk about that.
Oh, you got to be really on the spot with objections, otherwise they're considered waived, and they got to be made every single time a piece of objectionable evidence comes up, and that's something that you talk about quite a bit.
Right.
Is excuse me, preserving the record. If you timely object to evidence that shouldn't be brought in, you can keep it out. And if you don't keep it out, then you've established a trail for the appellate court to be looking at. You want to bring up the objection every single time, even if you're overruled. You just bring it up, and just for the record, Your Honor, I'm objecting to this evidence. I realize you've overruled me because you're a social justice warrior piece of shit. But you want to say that, last bit really under your breath.
Really under your breath.
Really, or better yet, just do the full ventriloquist and don't even let your lips move.
Right.
But yeah, that's it's but you got to make the objection to establish the record so that you've got a chance on appeal. Now, appeals are really expensive, and they are difficult as hell. But yeah, and there's a lot of different reasons to object to evidence. Some attorneys they throw out bullshit objections just to screw with the other side to break their flow or their concentration, and it works. It's nasty, but it works. I mean, I've done that myself.
Right. It's
Sometimes
entertaining when
you
it
do
works.
it's extremely entertaining when it works, and you can really screw somebody up. Usually, if you object and it gets sustained like 3 times, the other side's just going to withdraw the question and walk away from that idea, that whole train of thought. And at a certain point, if they can't, especially if it's a procedural one, like objecting to the framing of the question, or like assuming facts not evidence, that's a real objection. Objection irrelevant is a real objection.
Right.
Objection hearsay is a really weird one. When you open up the hearsay rule, you're opening up a can of worms. That is the one evidentiary rule that is swallowed by its exception.
Right.
And it's complicated even for a second-year law student to understand when you first understand it. So a layman is going to have a lot of trouble with a hearsay rule.
Right.
Simply put, it is an out-of-court statement being offered in court to prove the truth of its assertion. Well, so-and-so told me that she did this. Well, there you go. That's the hearsay rule. You're saying that she did this because so-and-so told you out of court, and you're saying in court that they did that. That's going to get blown up. That's a hearsay rule. That's hearsay evidence. There are certain times when that will come into play. There's a lot of exceptions to that rule. If there's
Right.
a past recollection recorded, you recorded it as it was happening. You recorded it because it's part of your job. You heard it from somebody who was going to die, but dying breath, dying declaration. You got this evidence from a whole host of things. Or the best of all is they admitted it. The other side told me. That is party opponent admission.
Right.
There's a whole host of things like that can get around the hearsay rule, but hearsay is something that happens in every single family court case. It always happens.
Yeah,
Because,
it's a
and this is one
necessary
of the
part
reasons,
of it.
yeah, you really want to just avoid that stuff like the plague, even though it might fit within one of the exceptions. It's too close to home, and there's too much room for interpretation. If you can get direct evidence that establishes the claim you're making with something tangible and physical, like a pharmaceutical receipt, a diagnosis sheet, a psych eval write up.
A
Those are
police
things you
report.
want. Police report. You don't want to be. You really try not to use things that are hearsay because they're messy. Once you start bringing them in, the likelihood that you're going to get in is dicey at best. And bringing in hearsay is hard to prove.
Right.
Even with a recognized exception that always works, you're gonna have trouble with it because it's very dicey stuff. If
Right.
you ever played those games as a kid where you tell one person one story, it goes through 5 people, a totally different story, that's where things like the hearsay rule exist for that reason alone, because it
Right.
gets changed through every iteration.
Talk to me about the differences between emotionally relevant evidence and legally relevant evidence.
I could say objection asked and answered, but I will go back into that again.
Fair enough.
Emotionally relevant evidence would be something that's relevant to the person that's asserting it. It's important to you, but it's not going to be important to the finder of fact. It doesn't get to the ultimate issue, whether this happened or whether this didn't happen. It's how you felt about it. Facts
Right.
trump feelings.
Always. Always.
They just do, and especially in court. Although these days that's changing a little bit. It's been changing for the last 40 years, and it's going the wrong way. But if you get a social justice warrior judge, as so often is the case, you might get a little bit of feels over reals.
Exactly.
as,
Let me
as the young
break
kids
in
say.
here. Yeah, let me
Go
break in
for it.
here real quick. Okay, guys, if you're paying attention to the stream, I see we've got 100 people watching. MGTOW Esquire is an attorney. If you have any questions you want to ask him, feel free to ask those questions in chat. You can put questions in caps and brackets, and then put either MGTOW Esquire or a question to me. If you want to ask me the question, that's fine. And then Lily will grab those questions and ask them. If you are on a Windows desktop, or you're on a Mac desktop or computer desktop, or you have Twitch TV, you'll see a little Bukkake choke slam that'll float up above the little dollhouse icon on the lower right hand side of your screen occasionally. You can use that to redeem those. There'll be a little box. If you hover your mouse over, you click that box, you could redeem those questions or those Bukkake choke slam points to ask questions as well. Those questions do get logged, and we'll go ahead and ask them. So if you have any questions, feel free to kind of start asking those questions now. If you have any legal questions about evidence or any other legal issue or issue relevant to the stream, feel free to ask them. Don't worry about holding back. So just wanted to, because I noticed there's not a lot of questions yet, but I just want to make sure that that option is out there for people that might be interested. Um, so with that, let's kind of get back to the conversation a little bit. As far as evidence is concerned, um, it for the layman,
Hmm.
would like say they want to present their, or protect their evidence for an attorney. Um, what is your advice on the best way for somebody to preserve their evidence for an attorney so that they can get the attorney? Like say they're going to get an attorney, for example, and they have this evidence. What in your opinion is the best way to
It
preserve
would
it
it would
in
really depend
general?
on the type of evidence. It would really depend on the type of evidence you're talking about. If you're talking about something that could be tampered with, something that's going to, like a photo that might be photoshopped, for example, you want to get the original from the source. Like you want to get the actual sealed report from the private investigator, or the actual and don't open the damn envelope. Take it to the attorney,
Right,
have the attorney open it up. So, to try and establish more of a neutral chain of custody so that the evidence itself hasn't been doctored. That's the idea, is to show to the finder of fact that this evidence is real. That's the way to do it. Um, there's, in most cases that doesn't matter very much, because you're talking mostly documentary evidence instead of testimonial for those kinds of things. Testimonial evidence, well, it's always going to be a little difficult to do. Getting a an affidavit from the party making the test, preferring the testimony evidence. You got a witness who makes a statement for you. They're not going to be able to use the statement itself as evidence. Not most of the time. They're going to have to come in and testify. But at least you've got something to try and bring that witness in, that you can show the judge, this is what this person's going to testify to, judge, so you can bring it through. Does that
right.
make sense?
It does. It does
Okay.
completely. Um, okay, yeah, and I totally get that. So let me ask you this. So for the people that are out there, okay, so they have their evidence, they preserve their evidence. Maybe they don't have an attorney. In your opinion, um, do you believe the best time to present that evidence is either at a motion hearing or at trial, or because I know different attorneys have different theories on that? What are your thoughts?
Well, referring to a piece of evidence in a motion hearing is fine, but presenting the actual evidence in a motion hearing is kind of dumb, since that's really not where you're doing that. The only reason to do that is as a response to discovery to the other side, um, just to let them know that you've got ammunition if they actually ask for it. If they don't ask for it, they don't get it. I mean,
Right.
unless you're trying to strong arm some kind of a settlement, it doesn't make sense to do that. It's much better to get a final judgment based on evidence,
Okay.
instead of some kind of settled thing that can be reopened more or less at a whim.
Now, just as a little reminder for the people in the audience as well. So once interrogatories are submitted, once requests for admissions of denials are submitted, and subpoenas are issued, um, are those the people who they're issued to? Are they under a duty to update that information as needed, or is it just a one time thing and you have to resubmit it every time you want an update? Talk about that a
One
little bit.
time, one time thing needed to be updated later. If it changes, it changes.
Okay.
Um, that's one of the reasons why asking for current stuff is, you're you want to try and ask absolute facts. You want to try and get to asking absolute facts that aren't going to change during the course of the case. Because if you're starting to ask things like, well, what's your bank account balance right now? that's going to change. Is there a duty to update? Honestly, I'm not entirely certain. I don't think there is. I think, I don't think there is a duty to update. I'm not sure. I could be wrong. I don't know everything about the
I think
law.
I think every state is different. I know in Washington State there's a duty to update. So
Yeah, I don't think there is. I could be wrong.
right.
It's been an awful long time since I've actually had that question posed. So,
Well, fair enough. Look at this. Maybe you'll go look it up after the stream.
yeah, hopefully.
Maybe not. Who knows?
I'll probably wind up looking it up, and then I'll be, well, can I go back and answer that? I am afraid I don't know everything, but I don't think there is.
Darn. I thought you knew everything. Shit.
I know.
All right.
It sucks not being omniscient.
There you go. Is there anything else? I think we've done a pretty good primer, a basic conversation about evidence and evidence rules and kind of the circumstances around evidence in a general sense. But is there anything else about evidence you think that's important to cover, or at least something to talk about at this point?
Well, looking out for privileged conversations is probably one of the things that should be. There are ways of getting around it. For example, the conversations a patient has with their doctor, that's privileged. But if you're asking the patient to get and divulge that, you can do that. The doctor can't do it directly unless you've got a waiver of some sort.
Right.
Lawyer-client privilege is another one of those. It's impossible to break. Well, normally impossible to break. Husband
Yeah.
and wife have a similar privilege unless they're both parties to a case. But you got to look out for that kind of stuff. When you're digging for evidence, you got to watch out for privileged conversations and things. It's difficult to get disclosure of those kinds of relationships, of what's going on in those relationships. Now if your evidence is that the ex-wife is screwing the doctor, that opens up a whole different can of worms, and you can go in there, but you got to prove it up. If you can prove it up, it throws out the privilege.
Right.
So that's where these kind of things come in.
Exactly.
So.
All right.
That's the only thing I can think of. I hope this has been helpful to folks. I really.
Yeah, I think it has. I mean,
see-
we've had a
I
good
see
hour
way too
conversation.
much. So I didn't go full potato. Darn it, man! I was
No.
aiming for full potato.
Yeah, so everybody knows he was trying to go global, man. He threatened me with global, man. I was like, oh shit, here we go.
Yeah.
I did my best to kind of rein in the cats there. So I think what we'll do now is if there's any questions, we'll open it up for questions. So Lily, the Q&A thought will give us some questions. So Lily, are there any questions for us or for MGTOW Square? Go for it.
Okay.
Before you do, MGTOW Esquire, I wanted to say thank you for taking the time out on a Sunday to come out and do a second installment of this. I'm hoping that maybe we can kind of make this kind of a, as time allows, kind of a semi-consistent sort of thing, maybe every other month or every couple months or whatever. Just as subjects come up, I think it's a good option for people, and I think you provide a lot of good information. So I just wanted to say thank you again for taking the time out and making this happen.
I absolutely love it. Yeah, I'm very keen on helping folks, especially men through family courts, because they've been so incredibly biased over the last 40 some odd years. So yeah, I'm absolutely on board to help. I may need to buy myself a better microphone, but
right.
Tech issues, what are you going to do?
Right. All right. So go ahead, Lily. Sorry about that.
You pimp-handed me again.
That's what you get. Thought lives matter.
All right. I do. No. In Caparosa asked, can using a recording device such as an audio or video protect you from a false allegation?
Very risky to do that, because there are one-party and two-party consent states. If you are in a two-party consent state and you record somebody without their knowledge, you are really hosed. You do not want to do that. Using recordings in a one-party consent state, will it protect you? It might, but it might open you up to other charges. It's messy. I prefer not using recordings of things like that, because if it's really, really relevant stuff, And if it was recorded by somebody who's professional, like a PI, it's a little more neutral and you're going to get a better result. Whereas, recordings tend to show what we want them to show. So, you called her a horrible bitch and then she's all in a rage and you start the recording. Well, it doesn't show, it's going to be thrown out because it doesn't show what came before it that led to that. That's why they don't really want to list. They don't really like that kind of evidence because it doesn't show enough. It doesn't show the entire unedited, uh, from calm to calm time frame. So it tends to only show the most dramatic part of it, and it doesn't really hold a lot of weight
because it's out of context.
Because context is king when it comes to recordings. And also, for the love of God, watch out for two-party consent states. They're murder.
Right. I would also go, for those people that are outside the United States, there are two-party consent countries as well. There are many in Europe that are like that. So just as an FYI. Next question.
You just gotta look out for that stuff.
Okay. Do you want me to go in like order of relevance or like kind of
just
key?
do them as they came in. That's fine.
Okay. So we have Hello Mandy says, DDJ, why do cocks and manginas choose to be male feminists? What do they get out of it?
They get access to pussy. They're thirsty. They're thirsty cucks. They're cucks for a reason. I mean, the thirst is real. They want breeding access, and so they run around and they virtue signal because they don't have dominance traits. I mean, I don't know. Maybe it's too much soy, but I mean, that's why they're cucks. So I hope that answers your question.
Okay. Chimpan Strong, question for guest. Is it possible to challenge the fact that the court never provides factual evidence regarding the element of jurisdiction? What is Rule 11?
Rule 11? Goodness gracious. You're talking federal Rule 11, I believe. That's the one that provides for sanctions as well.
Yeah, that's CR 11 sanctions.
Yeah, that one's really a little bit out of the ballpark. But challenging jurisdiction is always an issue, but it's rarely the kind of thing that it's usually pretty clear when there's no jurisdiction in a case. Somebody who lives in New Jersey suing somebody who lives in New York, and they bring the case in Arizona. Jurisdiction's a clear issue. What the hell are you bringing it in Arizona for? So I'm not sure I understand the thrust of the question, but yeah, jurisdiction's always an issue. The fact challenging a jurisdiction because they're not explaining the facts on which I don't really understand the question. I guess that's basically the bottom line. There's maybe you understand it better, DDJ?
Yeah, well, I mean, the idea of jurisdiction is that jurisdiction is established in a case so there's three types of jurisdiction. There's subject matter jurisdiction over the persons, and then I forget what the third one is, but basically those are the two main ones. You have jurisdiction over the parties, and then you have jurisdiction over the subject. The family court traditionally has jurisdiction over a subject matter of anything relevant to family court. And then the parties is jurisdiction of the parties, like what MGTOW Esquire said, where, if one person lives in New York and the other person lives in North Dakota, and then they want to bring a case in Arizona, well, there's no reason, there's no jurisdiction crossover in Arizona. And so that ends up being a challenge. Now, I think that the third jurisdiction I was thinking of was diversity jurisdiction, but that's not relevant in the context of family court.
Not at all. Diversity jurisdiction, that's, where you got somebody living in federal court in one of those two states. That's how you get jurisdiction over the New Jersey guy if you're one in New York. But you don't bring in Arizona. So, yeah, that's diversity jurisdiction.
Yeah, so, I mean, a diversity jurisdiction, I've never seen an instance where it's relevant in family court. Now, as far as CR Rule 11 is concerned, the thing that I would caution anybody about talking about CR Rule 11 is that it is very deceptively simple. And what I mean by that is that a lot of people talk about sanctions, a lot of people talk about CR Rule 11, but the reality is that it not only implicates procedure, but it also implicates your local statutes, your local laws, and there's usually in whatever jurisdiction, because I've seen it in multiple states, there's usually good case law about it. So there's always some interpretation by the courts as to how they're going to enforce it. So when you're looking at CR11 sanctions or when they're under consideration, it's a lot more complex than it looks. And that the rule, usually I've seen the federal rule, I've seen the state rule in a couple different states. It's very deceptively simple. So, there's whole books written about it. So just be careful with it.
There's an awful lot of stuff that you can find on a Google search that seems remarkably clear. It's not. Oftentimes, it's really not. If to tackle something like that, if you're looking at some kind of an issue like that, you're going to need a lawyer. You really,
right. Yeah.
That's not an area that, for example, it caught me kind of flat-footed because it seemed honestly a little irrelevant to the conversation we were having.
Right.
So,
well, I could see frivolous evidence and things like that, but again, I'm stretching for that.
Yeah, I mean, it's a fascinating area of law, but you really have to spend some time to master it, and that's not something that's easy to do. Even
Agreed.
for a lawyer, it's not easy to master certain areas of law.
Right.
So yeah, it's my quick and dirty explanation of the hearsay rule is a good example. It's quick and dirty. That's definitely not the end all and be all of the hearsay rule. The hearsay rule has books written about it. It's
right.
enormous.
Right.
So anyway, yeah, I hope that was a satisfactory answer.
Yeah, that's fine. Next question.
All right, I think this one might be a little bit of a double up, but we'll go again. Hey Layman, DDJ, why do men give so much power to women and feminists? What do they believe they'll get out of it?
Oh, that one's asked and answered.
Answer. And to reiterate,
getting their pee-pee touched.
Yes, absolutely. All right, next question.
I think this one's more of a statement, but here we go.
That's fine. Go for
it. Blood scene question. MGTOW Esquire. Add some grain to your mic. If you use Windows, you can find it in the input device properties.
Oh, the gain, mic gain. Okay.
I used to be really good with computers, but quite frankly, they've gone well past my skill level now.
That's okay. We can play with it another time, maybe between
streams. I apologize for my less than adequate IT skills. I can't seem to figure out where the gain section is in the control panel.
Well,
I'm not as tech as I used to be.
You're right. Well, this is why we have legal professionals and IT professionals. So you go to the right one when you need the right job, right?
Yeah, exactly. You're exactly right. If I was smart and was doing this in my office, I might have a better rig. But I'm not.
It happens.
Here, so
all right.
Next question. I have access to coffee and whiskey here, so I'm pretty happy.
I like it.
Okay. Hello, man. Question for the guest. What kind of lawyer are you, and is it legal to use lethal force on someone who refuses to leave your property?
That's a jurisdictional question. Some places it is, some places not. What kind of lawyer I am, without doxing myself, I've done smatterings of many types of areas of law. I have not done intellectual property. I have not done tax law. But pretty much every other area I have touched upon. I am presently a family law attorney. And as far as using lethal force when somebody, some states have the, the retreat rule? Some states don't.
No retreat law, yeah.
No retreat law. Some states do, some states don't. It's an ugly area of law that's being battled over constantly. It just depends. The more dog shit your state is, the less likely you're going to be able to use lethal force in your home.
Well, and on top of that, it's something that's been highly politicized. So yeah, check your state, yeah. check your local attorney. Next question.
Okay, this one's kind of off topic, but it's the next one in order. So, Nisho5 question for DDJ. How do you feel about the angry MGTOW that are mad at you for doing your own thing and having a female help out with your stream?
Here's the thing. Angry MGTOW can do whatever Angry MGTOW wants to. I think the only reason that Angry MGTOW is lashing...
I don't think it was the person. I think it was just Angry MGTOW in general.
Hey, Lily. Can you do a Celestina voice? Sorry, Lily. Had to throw that out there.
That's fantastic. Go ahead. Okay, so here's the thing. I want to make sure that something's abundantly clear with my stream that I think people have been confused about. I'm MGTOW, but my YouTube channel is a red pill channel that is geared toward red pilling men and bringing them to MGTOW. So my target audience is not MGTOW content. And the reason my target audience is not MGTOW content specifically is because almost all the MGTOW content has already been made. You can learn about any MGTOW philosophy that you want to, or any aspect of MGTOW, legitimate aspect of MGTOW you want to, from any of TFM's videos, from any of Sandman's videos, from any of Marcus's videos, or Stardust, or Spetsnaz. I mean, there's so much good information out there that I'm not going to be a hashtag #MeToo MGTOW guy. Now, why do I have a Q&A thought on my show? Why did I interview Barbara for you to see? Why did I interview Elizabeth Hobson? Why did I do the conversation with Poda Person? Well, let's talk about that a little bit, and let's play some chess and not checkers. What do blue pill men want? They want pussy. Why are they cucks? Because they're thirsty. And where do they go? They go where women are. So, Lily has a pleasant voice, and she's not horrible to look at. So she will bring the cucks to the yard. She will bring the blue pill men to my stream, and they will be interested in listening to what I have to say because they want to wait to talk to her. She'll interact with them in the chat. She will provide a more welcoming presence to female feminists who want to come and debate me because they will be more likely to. Poe the Person was more willing to have a conversation with me as a result of it. I've had other people who are not MGTOW who've reached out to me since they've seen that I'm willing to talk to women. And what this does for me is this gives me access to their audiences, and it allows me to red pill other men. You know, Barbara For You to See has 105,000 followers on her YouTube channel alone. She has 15,000 followers on her Twitter, and she went out of her way to advertise for the stream earlier today. Now, do we agree on everything? Well, no. Do we have to agree on everything? Absolutely not. She knew what she was walking into before we had the conversation. And did I press her as hard as I could have? Well, no, absolutely not. But the question you got to ask yourself is, had I pressed her as hard as I could have, what would it have gained me? All it would have done is potentially pissed her off and pissed off her followers, and they would have just tuned out the MGTOW message. Whereas if I treat her with the kid gloves and maybe throw her a piece of candy, what that ends up happening is that then all of a sudden the blue pill followers take a better or a more objective approach of my content and what I'm doing and other MGTOW content creators. And what that does is that hopefully red pills some of these men. Now, are all of them going to get red pilled? No, absolutely not. But some of them will. And you know, again, my target audience is not the red pill, or I should say is not the MGTOW community. My target audience, my goal is to red pill more men. My goal is to bring more men to MGTOW so they understand that they're not alone, so they understand that they're not isolated, and so they understand they don't have to be cucks to these bitches, so that they don't get hurt, so they don't get divorce raped, so they don't get hammered. That's why I have MGTOW Esquire on today. It's why I have talked to Lily and she's agreed to be the Q&A thought for my show. So you guys have to understand that I could run around and be like, don't talk to the women's ever. And look, that's retarded. And if you're listening to the stream right now and you can't handle dealing with women, then my suggestion is that you have to figure that out, because look, if you're a thirsty cuck and you're chasing these women around, you're going to look like a rapist. You're going to look like a lech or some kind of creeper, because you're so thirsty you're chasing these women around. But the exact opposite is true as well. If you go out of your way to avoid women at every chance you get, you go into the bank and you're like, oh, I'm not going to go talk to the female bank teller, or you go to some other place of business that you have to do business with, and you're not going to deal with a female employee who happens to represent the business. Well, now you paint a bullseye on your head, because now you look like, oh, this person is they're weird, or they're emotionally defective or something like that. The point is that in order to ghost, in order to live a MGTOW philosophy and to keep it drama free, you have to blend into your background. So you have to pretend to be what they expect you to be, and then hopefully the more predatory of these women will dismiss you and you can live your life. It's why I created the video, Avoid Relationships, Not Women, because women are in the workforce. They are over 50% of the workforce. They are 2/3 of academia, both college students and professors. So in order to be successful as men today, we have to know how to successfully interact with them. We have to know how to create professional relationships with them in a way that allows everybody to succeed. Now, at the end of the day, sure, don't worry about committing, cohabitating, or marrying any of these women, because feminism has destroyed the social contract between men and women. And the reality is that Lily agrees with that. Lily agrees that the social contract has been destroyed. Lily understands that there is potentially irreparable damage done. So the fact that she's willing to humble herself and be here, I think, is a good thing. But at the same token, if you think that me not talking or me talking to these women makes me less of a MGTOW, well, that's your opinion. But I'll tell you what, while you get upset at me and maybe state some harsh opinions about me, I'm going to focus my attention on the 50 blue pill men that might follow Lily, or that might follow Barbara, or that might follow Elizabeth Hobson, or any of the other women that I talk to. And I'm going to focus on trying to red pill those men, because I'll tell you what, those men need me. They need my message, and they need MGTOW more than the MGTOW community. You guys have already MGTOW. The content has already been created. It's already there. So you know what to walk away from. And you should, if you've been paying attention to Turd Flinging Monkeys videos at all, you should know what to live for. You should be starting getting ideas of what to live for. And so, and if you're in the audience and you're a blue pill guy, or you've recently discovered MGTOW, you should be in my chat, and you should be interacting with the red pill guys here, with the MGTOW guys that are here. Lone Wolf is in my chat. I've seen Nemo in the chat. Mac Attack is in the chat. We have Grizzly MGTOW here in the house. We have guys who are experienced MGTOW, who are willing to talk with you, have conversations with you, and to help you get out of being a blue pill cuck, to stop being a mangina, and to quit being a goddamn utility for a woman who doesn't give a shit about you. So, yeah, there's going to be people upset about it, and that's fine. But my message isn't going to change, because, I have to help the men where they're at. And these men are following these women. So I have to talk to the women to bring the cucks to the yard. And that's my strategy. And I've been pretty open about it. I'm not lying to anybody about it. I'm not going to conceal it or hide it or anything else. And, if I can have a good conversation with them and share some good information, then absolutely I will. And what I mean by that, if you're confused, look at my stream with Elizabeth Hobson. It is chock full of information about domestic violence and about how shitty everything is. So yeah, so that's kind of my view on that. And I'm looking Mima Gind. I know you were saying that I should cut this answer out and put it in a second video. I actually don't do this with this stream. This is why I cut the stream off at 2 hours, because 2 hours should be fine. If you don't have an attention span to sit through a 2-hour video or an hour and 45-minute video, then my suggestion is go to a professional and get some medication. Next question.
Okay, next question is I'm sorry, I can't pronounce anything. It's a question for both of you. My ex tried using my text against me with handwriting on the side to try and twist my words to make me look bad, but my lawyer had it thrown out. Is this normal, or did I get lucky?
It looks to me like a fairly normal thing. Was that question for me?
Go for it. Yeah, go for it.
Yeah, that's a fairly normal thing. If it's just, that's getting something thrown out because it was edited, that's a fairly standard thing. It's a pretty good case in point for the assertion that the closer to the source of the evidence, the person who's presenting this evidence could have produced it or doctored it or messed with it. That's pretty much what we're saying. Is it more likely to get thrown out because it's been tampered with?
Right.
So I mean, I hope that's useful, but I don't think you got lucky with that. I mean, you may have gotten lucky that the attorney knew what he was doing,
right?
But that's not uncommon to get something like that thrown out. At least it shouldn't be uncommon. Not every judge understands rules of evidence.
That's true. You have to spoon feed it. You have to spoon feed it to them.
Sometimes you do. Some judges are excellent. Some judges not so much.
Right. Now, I will say this. I'm an asshole. If I see some piece of shit present evidence where there's like fucking handwriting and shit on the side, I'm just going to go right after him and I'm going to be like, Your Honor, why are we allowing these people to alter the evidence to try to change the context? Doesn't this sound like bad faith to you? Shouldn't we be talking about attorney fees or something? It's a waste. I mean, I would get all like pseudo dramatic about it, and I would just start kicking fucking hard because then the judge
You
would be
have
like,
to.
wow, this guy is an asshole, but he's got a point. And what's funny about it
You have
is
to.
that you do. And too many of these attorneys, the problem with cucks is that there are cucks in every field. And if the attorney is a cuck and you just go in and you just like slap your dick on the table and you're being like, I am here, the fucking judge might just laugh about it and be like, this is hilarious. I've had a shitty day. Okay, I'll sanction him. And it happens sometimes. So yeah, go full retard on him. Go full global man.
Yeah, you can have a lot of fun, and honestly, sometimes the judges are good enough that they actually enjoy a chuckle.
Yeah, they
So
really do.
it's a risky thing to do if you've got a judge who's taking things deadly seriously, but there are times for levity in court, and you can get away with it. Now, if you're a party, be very careful with that shit.
Very, very careful. I can get away with it because I've like as a party because
Yeah,
I have a legal background, but
yeah,
you do wind the judges up occasionally. So yeah,
yeah. Sometimes you can, and sometimes I
yeah,
mean, they are human. They are human too. Some of them.
some of them.
But you do that with an SJW judge, and you got a problem. There's a contempt citation coming your way.
I had a case where my second ex, we were in court, and my ex's attorney was actually friends with the commissioner, and so I submitted an objection, but I put it in writing because I knew she was going to shut me up and wouldn't let me talk because she's an SJW. So I had my objection in writing. So I had it. I walked into court that morning. I filed it with the court clerk. I had it stamped received. I put it in her box, and then I walked it into court and I presented. I was like, I have an objection, and she just looked at me, rolled her eyes. The whole courtroom's full, and she's like, "Of course you do." So she knew. Like I'd been in
Yeah,
front of her a few times already, so she already knew. She was like, "Oh, this fucker." So
yeah. That's
so
it's awesome. It happens.
yeah, so and again the courtroom's full, and so I realized that she wasn't going to let me talk, and she was going to shut me up the first chance she got. I was like, well, I put the objection on paper, and I handed it. I said, I'd like to hand it to the court right now. I've already filed it, and so it's in the court file that you may not have yet because I just filed it this morning. I was like, but I want you to read it so it goes faster. So she read it, and it was basically pictures of her LinkedIn endorsing my ex's attorney and basically asking her to recuse herself from the case.
Mhm. Yep,
So
that's the way to do it.
and the best part about it, she had no clue it was coming. So she looks up, she looks at me, she looks at my ex, she looks at the attorney, and she looks at the audience, and it's a packed courtroom. And she looks at me and she kind of smiles and she goes, I knew I should have shut that LinkedIn account down. Spoke it right into the record, right into the
Oh yeah.
record. And I had her in a corner. There was nothing she could do. She looked at me and she basically she wouldn't recuse herself, but she ruled in my favor because I had her backed into a corner. But again, it was something that was completely off the wall, and she knew. But you have to know how to present that stuff because they will look for every excuse they can to sanction you. You just got to be really careful.
You do. They do. And if you get a like I said, if it's SJW lawyer or a judge rather, you're man, they have no sense of humor. They just
No,
don't. They're just looking to be offended, and as soon as they're offended, they're going to find a way to find you in contempt.
right,
So you got to read your audience very carefully when you're dealing with those kinds of things.
right. Or next question, Lily, are you alive?
No, I died briefly for a second. It's okay. I'll make it through.
It's all right. Vampires
Okay.
do that. I get it. Go on.
Well, it is daylight now. Red Rachel Ghoul. Question. I'm a guy living in Europe who has a story with a lady living in the US, resident non-American. Do I risk anything in the hashtag #MeToo era if I ghost her, even if I tell her to F off?
Repeat the question again.
Okay. I'm a guy living in Europe who had a story with a lady living in the US. She's a resident non-American. Do I risk anything in the hashtag #MeToo era if I ghost her? Can I even tell her to F off?
Is that a story or a soiree?
It's definitely a written story, but
That's really
I
weird.
don't know.
All right, so we're trying to apply context to this. So if you have a story written, or I guess take her name off the credits and publish it yourself. If it's a soiree or you have like a romantic relationship with her and English is not your first language, I'm going to assume that that's what you're talking about because of the way it's written. So, Raish, I would say this: ghost the fuck out of her, pop smoke and go.
Yeah, it's in the Me Too era, ghosting is your first offense,
Yeah,
and it's ghosting. It sucks, but the truth of the matter is, it is the first offense with this kind of Me Too stuff. There's it's hard to fight something that's not there.
you
It's
can't
just the
prove a
way it is.
negative.
It's especially if they can't find you again.
Right. All right. Next question.
Okay, this one has it either has an acronym in it or it's a keyboard mash, so I'm gonna say it anyway. I apologize in advance. Walkaway has a question. How exactly do I present answers from the other party in RFO for motion hearings?
RFO, probably RFA, request for admissions. That's probably what they're talking about. RFO.
You shouldn't. So, number one, a request for admissions is done ex parte. It's not actually done at a motion hearing. Now, when
it's not even ex parte. It's just a
right.
document. You send the other side. They got 20 or 30 days, depending on your jurisdiction, to respond, and it's basically they respond true or false. I'm not sure if that's what he's getting at, but I think that's probably right.
Yeah, if we didn't answer your question, or maybe you can reword the question and then resubmit it, that would be fantastic.
He does have a couple follow-up questions, but if I'm taking them in order, they're
Request
a little
for
bit
order.
later.
All right.
Request for order. That's not.
Yeah, I'm looking at
something
the chat.
Yeah, that's not something I've seen in any of the jurisdictions I've been in.
Nor have I. What are the follow-up questions? Let's see if maybe we can provide some context based on those.
Okay, so there's two of them. I'll just read them both. So the first one is, I'm in California. My ex records everything. Exchange of my daughter without my consent. I have evidence she is recording me. What can I do? And then he says, the second follow-up to my first question. I meant answers to discovery.
Okay. Since it's California, why don't you go ahead and answer that, MGTOW Esquire?
Still wouldn't. I'm not familiar with request for order. That's a new.
Yeah,
put that way. But I mean, that could be a change. It's been a long time since I was out there, so.
Right.
Yeah, I don't know. Now, and quite frankly, with all the soiree story and everything else swirling around, I'm not sure I understand the first question to get the proper context for it. I'm afraid I'm a little lost with what he's actually aiming for.
Well, let's address the follow-up questions then.
I believe California, and don't rely on this, find out locally, but I believe California is a one-party consent state, so she's okay recording everything. If you're trying to stop her from it, I'm not sure I understand. If you want to go through reading that question again, the first question, I might be able to sort this out a little bit.
You're on, Lily.
Okay. So I'm in California. Wait, is this the first question or the second?
First one, yeah.
Okay. How exactly do I present answers from the other party in RFO, motion for hearings?
Okay, now motion for hearings, I get it. It would be submitted as an exhibit. The answers would be submitted as an exhibit. But it sounds to me like what you're talking about is more along the lines of a summary judgment order, which those are massive.
Yeah.
A layman trying to produce a summary judgment, that's not a good idea.
It's a shit show waiting to happen.
That's a shit show waiting to happen. That's not a good idea.
Okay. So I think we've answered the recording question. We've answered the other one. The thing that I would say, as far as like the ex recording you, try to do the custody transfers in a public place. Don't try to go to her place, or don't try to go to your place, because what she might do is create an argument. And one of the first things that MGTOW Esquire talked about is that video recordings, nobody likes them because nobody knows everything, because you can cut the video and edit it out of context, which happens all the time. So that's the only thing I would add on to that.
Yeah, that's right.
All right, next question.
All right, next question from Chimp Handstrong for the guest. Why are there only one bar association, and why do they not allow competition? Isn't it a systematic conflict of interest to have both lawyers and the judge licensed by the state, which is the accuser? If the public defender, all three are also paid by the accuser. Your thoughts?
It's a very complicated question you got there. It's an interesting one. Um, Theoretically, if the whole licensing body really doesn't care as to what somebody does once they're licensed through the state. Is it a conflict of interest to be licensed through the state? Not really, no. There was a point in history, in California history specifically, where the state bar was challenged because they were using resources to affect political causes. They were donating money from the state bar coffers to left-wing causes. And what happened is the governor at the time, Pete Wilson, yanked the funding from from the state bar, and that year the bar cards were printed on cardboard, just little cardboard sheets.
Oh
It
my
was an
God,
epic
that's
thing. It
awesome.
was an epic spanking of the state bar because the state bar has a very definite agenda, and it's definitely not. It's definitely a feminist agenda. It's definitely left wing. Every single part of it. All state bars are the same. They are all left wing. Even the ABA, they are all left wing. But just because the system's corrupt doesn't mean you walk away from it. Well, that's kind of runs contrary to MGTOW. But the truth of the matter is, you can't win a fight if you're not in the fight. So, I was admonished by friends of mine to get back into the law because just because the system's fucked doesn't mean that other people are going to get fucked if you're not there to fight.
Right.
So that's why I'm sticking around in law.
Well, my
Trying
my my
to
position is this,
get
and you
them
may
on.
disagree. Yeah, my position is this, and you might actually disagree with it. We have a tricameral form of government. I personally believe that the Bar Association should be part of the executive branch. I think that the licensing of attorneys should go through the executive. Um, and then I think obviously the enforcement of that should go through that licensing office. Does that make sense?
It does, and it's a very interesting way, an interesting to think about because right now nominally it's through the judiciary. It's,
Right.
that's where it is. But you know, each state, it's one of those 10th Amendment things.
Mm-hmm.
Uh, it'd be nice if there was a more unified structure, but that would fly in the face of the 10th Amendment.
Right.
So harmonizing all the states together, increasing the size of the federal government, it's not a good result either.
Not at all.
So as it currently sits, each state makes up their own mind. Each state bar has different quirks, and honestly, it's kind of, to use a TFMism, it's the least shitty solution at this point. It'd be nice, but I think the best way to handle it is to red pill some of the attorneys and judges.
Yeah.
Red
Yeah.
pilling.
Get them to fucking
That's the
take
only
their
hope.
dicks out of purses. Right.
Exactly. That's really the only hope. And it's, to go back to the earlier question you were talking about, I actually had two things to mention when you were talking about the angry MGTOWs getting angry that you had women on your show. I mean, there's two parts to it that I wanted to mention. MGTOW, MGTOW and feminism, they're often echo chambers where you're only talking to your own side, people who already agree with you. If MGTOW remains that way, it will never be larger than it is. It'll only expand after somebody gets torched really badly. Um, that's not a good idea. Getting our ideas out to people who are not inclined to search them out is the best way to go. So your channel is a brilliant way to handle it. That's an excellent idea. And I'll admit, as soon as you were talking about having I think her name was Barbara
Yeah.
and Lily and Poe, the person, that reminded me of that the Tubes song from the '80s. She's a beauty. You get to talk to a pretty girl, and only going to cost you $1.
Right.
So it just, I mean, that's the humorous side of that question that I'm bouncing around in my head.
Yeah.
But
Yeah. There's the entertainment values there.
yeah, so I just wanted to throw that out there. But yeah,
Thank you. All right. Next question.
Okay. Tim True says, question: why do you guys practice law? Law is horror. Leaves me with an impression that law is concerned with justice and fairness was forced on court to testify against innocent man and everybody was kissing the judge's ass.
Well, it's always prudent to treat judges, kings, and megalomaniacs with very polite words. You know, it's as I said, the legal system may be fucked, but if we don't stay in it, more people get fucked. It's the least shitty solution to be involved in a system that is grinding people up like hamburger to try and help them so that they don't get ground up. That's basically why I do it. I don't know, DDJ, you got your own answer to it.
Yeah, I mean, for myself, where I'm at. I mean, I would still I've actually been out of active practice of law for almost 10 years now. Um, I'll touch a case, I'll cherry pick a case, I'll work with an attorney here and there on a particular case, and then that'll. But I'm not an attorney. I want to make sure everybody knows that I'm a paralegal. Um, but I'm competent and capable to do just about everything, including if I had to walk into court for myself because I can't represent other people. But I mean, I've written legal briefs, I've done the research, the memos, collected evidence, that kind of thing. I've done pretty much all of it. I had some very very good mentorship and some very kind people who would who were willing to help me along that path and teach me and hone my skills. So and it took me a long time to get the level of knowledge that I have right now. I don't actively do this as a full-time employment or any kind of full-time job, primarily because I got disgusted, just like a lot of people do. But I think that informing people of kind of like my personal opinions about what it is and bringing, legal professionals like MGTOW Esquire on the channel and having these conversations, I think that they're important because the best time to prepare for the storm, or what's that quote from Spy Game? When did Noah build the ark? Before the rain.
Yeah,
You know,
exactly.
it's exactly what it is. So if we can red pill people to let them know the dangers of family court, to let them know the dangers of what divorce looks like and the damage that could be caused before they commit to these women and before they get themselves in these situations, then that's my goal. Is to act as a preventative rather, because an ounce of prevention is worth a pound of cure.
Absolutely. The original Latin maxim, peace, prepare for war. It's too
Right.
late to learn martial arts once somebody decides to target you. You have to
Right.
learn it beforehand, just like it's too late to learn how to swim once you're neck deep in the water.
Exactly. All right.
So, marshaling your resource before you're heading into a family court case is prudent. Lining up an attorney before you're a month away from trial is a good idea,
Or even 3 months.
or even 3 months. You just don't want to. You don't want to try and tackle things too late. You have to read the tea leaves a little bit, see where things are going, and that's one of the things the whole red pill movement is about: explaining female nature, getting people familiar with things that happen, hypergamy, being familiar with all these concepts gives you an opportunity to read the tea leaves and see which way this is going. So
Right.
in your relationship, if she starts doing things that are tipping you off, take action. Don't just put up with it,
Right.
because it's just gonna get worse.
I agree. All right. Next question. Oh, and by the way, we're gonna kill the stream at 3:30 Pacific Standard Time. That's about 20 minutes from now. So kind of an FYI. So we'll work on these last few questions and then we'll go from there.
Okay. So, Hello Man says, for the guest, what is required to take the bar? Do you have to be a lawyer or have a degree in law to get the bar?
Some jurisdictions are different. In any individual state, if you are going to an ABA accredited law school, you could take the bar in any state in the union. If you are going to a state accredited school, you could take the bar in that state. It's going to vary from state to state. Some states have reciprocity with other states. I can tell you personally, no state has reciprocity with California. They don't. California lawyers do not get to waive into any other state because California has the hardest bar in the world. It's 3 days long and it's brutal. Um, there are some states that allow the the reading of law. That's where you get jailhouse attorneys, where these convicts, they have time on their hands, and they sit in the law library at the jail and they read up. They effectively become attorneys because they've studied it for years. They've had nothing but time on their hands. And some states allow that, some states don't.
There's also they also have, like, Washington State has an apprenticeship program where if you have a bachelor's degree and you have an attorney who is willing to apprentice you, and you pay the bar and you jump through like the little hoops that they have to do like the follow up to verify your knowledge, then you can become an attorney after 4 years if you jump through all the hoops the bar association requires.
That's correct. I mean, it's going to vary jurisdiction by jurisdiction. It's just what it is.
Right. All right.
The quickest way is to go to an ABA accredited law school.
Do the 3 years.
That's 3 years in hell, 3 days taking a test, a couple months getting ready for it. It's tough, but it is what it is.
Right. All right. Next question.
All right. Next question. Erect Banana 69. Just had to say that. For the guest. A friend owns a house in a US state that has common law marriage. Is it possible to cohabitate with a partner in the common law states without eventually being deemed common law married by the court and subsequently divorce raped?
Simply put, no, it's not. It's the reason why the rules of MGTOW are don't cohabitate, don't marry.
I will say this, though. I will say, if you're not in a romantic relationship with them, then you can't have common law marriage. But that's a rebuttable presumption, and you're still taking a huge risk.
Mm-hmm.
But yeah, don't commit, don't cohabitate, don't marry, ever.
Yeah, don't, because it winds up being awful.
Okay.
I'm watching the chat too. It is entertaining. I shouldn't do that. I should focus.
Yeah, it's okay. It's fine.
It's been a long stream. I'm enjoying myself.
There you go.
Okay. Layman asks for the guest. If a judge does something unfair in court, how do we take them down? Can you sue too, or what should I do? What should you do?
Can't sue.
There goes the nail polish.
You can't ask them to recuse themselves. You theoretically could file a grievance against them, but it's probably not going to go anywhere.
Yeah. Judges have absolute immunity for anything they do on the bench.
Yeah, they do. It's also why they have the power of the contempt power. They're going to do unfair thing now and again. That's just the way it works.
Yeah. And that's a very complex level of law, and it's something that you definitely, so like even like general attorneys, many general attorneys are not specialized in that law, but that's such a highly specialized area that you would want, like if you even had concern about a judge that was like that, you would want to find a highly specialized attorney, and in most jurisdictions you may only have one or two.
Yeah, it's tough. That's a tough one. So,
all
right, next question.
Okay, Walkaway says it's a question. They say, sorry, I'm retarded. You're not retarded, just by the way. When presenting discovery answers to the judge, do I produce the whole discovery at the same time, or do I just present the answer I need the judge to see?
Well, I think the proper way to do that is the answers to discovery go as an exhibit to what I'm trying to do, or in the gets offered as evidence in the trial. If you're in a motion and you're trying to move something forward and get a few things determined so they're all nailed down before the actual trial, you put it in as a motion. Just as an exhibit. Now, would you refer to the answer in the motion? Yeah, you bet. But you would actually put the context, the whole discovery responses would be attached as an exhibit. I don't know. I hope that answers the question.
I'd like to add something to that if I could.
Sure.
Not only do you need it attached as an exhibit, but if you have to make a motion based on the discovery, you better have a signed sworn affidavit as well, because the exhibit by itself sometimes, depending on like what you have, may not be enough for a judge. And if it's an SJW judge, they're going to fucking nitpick everything you do. So you want to make sure you have your motion. Yeah, you want to make sure you have your motion. You want to make sure that you have your affidavits, and then you want your exhibits attached to your affidavits so that there is no issues at all. That is the strongest. That's the best way to make sure that your evidence is properly before the court in case you have to take an appeal.
Yeah.
Okay. So next question. Someone's asked if they can use their choke slams on the next stream.
Yes.
Yes. That was easy.
Easy is good. I like easy.
Okay. Again, the name I can't pronounce because I just suck.
Speaking of which, I have a question. I mean, obviously you're having some challenges there, but you didn't seem to have a problem with the erect penis earlier.
Jesus.
It was
Just
a
putting that
banana,
out there.
actually.
Oh, sorry, erect pan, but penis, whatever, banana, whatever. Go on.
Bananas are way more sexy. Don't know what you're talking about.
Okay, if you say so.
Okay. So the question for both of you. It's kind of like two parts. So I'm going to say them both, and then you guys can just answer them. I plan to take my ex back to court over custody, both legal and custodial. My aunt told me to go to a men's rights lawyer. Is it a good or a bad option? And what questions should be asked when I'm trying to find a good attorney?
Do you mind if I take the lead on this?
Go for it. Go for it.
All right.
Please.
We did a stream about a month ago where MGTOW and Esquire and I talked about how to interview an attorney, how to prepare to go to an attorney. It's about a 2-hour stream. We went into that in extreme detail. How to set your case up, that kind of thing. My personal opinion is it really depends on the men's rights attorney. If it's because I like in Washington State, there are guys out here who advertise as men's rights attorneys, and they're really male feminists. So you have to be careful. MGTOW Esquire, you want to add on that?
Yeah, there's, if you could find a real divorce for men's only attorney, a real one, if they're real and they're good at it, that's somebody who's going to be a very talented attorney, because you're going up against you're fighting the cultural narrative. Men are bad and women are good. That's going to be somebody who's got some talented skill. Now, if they lose all the time, that's not going to do you any better than some fresh out of law school guy. So you're going to have to. I would recommend watching the stream, that first, to give you some pointers as to what to ask the attorney. Get an idea of what they know, because otherwise you're flying blind. So yeah, that's my answer.
I was going to post a link, but then I was like, there's no way I can post a link. So
if they search the website, they can, or search my YouTube channel. It's the Layman's Legal Clinic. It'll be the first one. This one's not posted yet, but I'll be putting them both together. And they're also, if you go to the playlists, it's going to be on my my live, or not my live stream playlist, but my weekly show playlist. All right, next question.
Okay, it's the last question that I've got. It's kind of, I don't know. We'll see how it goes. Nisho5. All the men in here are complaining about women. If you had a chance, would you? Question mark. If so, then shut up. I can't really make sense of that one.
That's kind of.
If you had a chance, would you what?
I don't know. There's just a question mark.
Well, I'm going to go ahead and assume then. I'm going to assume context. No, Niche 5, there are a lot of men out there that are one blowjob away from the plantation. Okay. And MGTOW is growing exponentially. And the thing about the red pill, for example, ever since the Cassie J documentary came out, now it's vogue to say that you're red pilled. And there's a lot of guys out there that are like, oh, I'm red pill, and they're not. Now, I coined a term of, I don't know, a month or two back called the purple pill power bottom. Basically what it is it's like some guy that tries, like outwardly, he looks like he might be red pill. He looks like he's alpha. He looks like he's not, has these issues, but it turns out that at the end of the day, he's just a cuck. He's just a cuck cosplaying as red pill. And there's a lot of traditionalist women that are very gynocentric who are cosplaying as MRAs. So, it is what it is. I mean, the reality is that, and I said this in my stream with Apocrypha the other day. I'm a reluctant MGTOW. I don't want to be MGTOW. I love women and I enjoy my time with women, but I'm MGTOW because it makes sense, because observable reality and verifiable facts clearly demonstrate that from a self-preservation standpoint, it is the way forward. And so, um, for myself, if I was ever to consider any kind of commitment ever again, I would have to really look at, is feminism done? And I don't mean going to a country that's not feminist, because all these countries that are not currently feminist, feminism is coming to them in droves. Foreign aid from first world countries is going in there, and feminism is linked into that. So that's an issue. Um, so yeah, I mean, I think again, this is why we promote MGTOW. Don't commit, don't cohabitate, don't get married to these women. Try to avoid relationships with the exception of necessary professional relationships. Learn how to interact with these women without getting caught up and without letting the thirst, get you dry.
Yeah, it's particularly sad for the younger kids, the younger men, because they're in this toxic cesspool, and there's no way. I can't imagine there are too many MGTOW who aren't reluctant MGTOW. I believe that's pretty much universal, but maybe I'm wrong. Um, but for the young fellas, this is a fucking shit show.
Oh yeah, absolutely.
Until there's a artificial womb and sex robots, and we're getting towards that at a incredible leaps and bounds.
Oh my God, 2018 is going to be a bang year.
Oh, it is. That one I watched that one Ryan Davis, I think it's right, video.
Yeah.
Oh my God, the fact that it's getting so much play everywhere. Holy shit.
Have you seen the
Amazing. I saw your videos.
Yeah. Yeah, Ryan Davis's videos had over 10 million views.
Oh yeah. That's definitely going to stir the pot. That's awesome.
Yeah.
Oh yeah. Oh yeah. And just the way he frames it is.
Yeah, it's fantastic. I see some more questions in the chat. You want to take them? We've got about 7 minutes.
I was just about to ask you. All right.
I'm game.
So the banana is back, because we all know we love it.
Does it taste good?
For DDJ.
You didn't choke on it or anything, did you?
I never choke.
Good to know.
Okay.
Go on.
Question for DDJ or even the guest. Are you willing to produce a list of books that you find beneficial to living a good life? For example, I am now reading 48 Laws of Power, earlier suggested by DDJ.
That would take quite a while, producing a list like that.
Yeah, I would agree. I would say
it's not a bad idea, but it's definitely something that's beyond the scope of one stream.
Yeah. I would say anything on Stoicism. Marcus Aurelius Meditations is a very good short book, but it's something that you can read multiple times. I'm a fan of Sun Tzu's Art of War, Miyamoto Musashi's Five Rings. There's some really good war history books. I mean, the book that what was the original book that We Were Soldiers, the movie was based off of? That's a fantastic book.
It's a lot of books like that. There's a wealth of. And the other thing these days is you want to look for original, because they do tend to like to edit history.
Yeah.
One of the other ones that I would add that's kind of an out of left field one is The Prince by Machiavelli. That's another one.
Fantastic book. Yeah.
Yes. Just understanding the concepts contained in that book, that's a little bit of a red pilling in and of itself.
Right. Now, the other thing that I would say too is not a book, but it's a website, is to do a search for a website in quotation marks, is the Misandry Bubble. That is a red pill classic.
Yeah.
Oh.
Yeah, there's a long way to go, but I tell you what, that Ryan Davis thing blew my mind. The fact that it got as much play as it did.
Oh my God.
Holy shit. That one doll is shaking shit up. Because most people still believe that those dolls are just the blow up dolls you see everywhere,
Yeah.
It's not that world anymore. 2018's shake shit up.
Well, guess what? The dollhouse sells them. They're cheaper than the average engagement ring.
Oh shit. They're certainly cheaper than engagement ring. They're cheaper than a wedding. They're cheaper than most dates. Well, a string
And
of them.
highly
Anyway.
customizable.
And highly
Custom.
custom. Right?
Yeah.
Yeah.
I tell you, the dollhouse has definitely grabbed a hold of a lightning bolt. They are definitely on the right path. Holy
Well,
shit.
there you go. All right. Next
They
question.
got to be buying Ryan Davis a fruit basket or something. That's the
Yeah.
best advertising ever.
Ever.
So yeah.
Okay.
Hey, let's hope your video gets that much play.
I'm hoping.
DDJ, have you talked about your massive discovery list of questions yet? I don't know what that means.
Yes. Last stream. Next question.
Okay. What's the purpose of law court? Fleece the small man? Will the public ever lose trust in it completely and just toss it sideways? Now we can see that it's a shit show.
The court is there for when people don't agree. It is considered the court of last resort for that reason alone. You don't want to go to court. If you can avoid court, do it. You can even have attorneys to help you avoid court if they're good negotiators. But it's necessary. It's a necessary evil. MGTOW Esquire?
That's absolutely right. That's absolutely right. That's 100%. And I'll tell you, there's yes, the courts have been completely invaded by social justice warriors. But I did hear a judge in a hearing mention the stealthing law and how unfair it is in terms of parity. How, you know, a man takes a condom off or the condom breaks and he's a rapist all of a sudden, whereas if the woman lies about being on birth control, that's no crime. When you start hearing, he was talking about it in very vague and general terms. When you start hearing judges talking about that kind of red pill shit, that's something. And I'll tell you, the social justice mentality invaded journalism first. It's one of the first areas it invaded. And now look at their reputability. How reputable are they in 2018?
Oh yeah, they're dog shit.
Journalists, they may as well just respell it, just call it journalists. They're worth nothing.
Right.
You see something in the New York Times or you hear it on CNN and you think, if I can find 18 other sources to verify the information, I might be able to believe it. It's horseshit. They're full of shit.
Exactly.
They're so roundly mocked. Now, can that happen to the legal profession and courts? Yeah, that can. If it's happening to journalists, it can happen there too. But the way to fix that is for people, judges, lawyers, to be red-pilled and start doing what they're supposed to be doing. You're not a judge to make the world a better place. You're a judge to actually find out what the facts are and apply the law to those facts. That's it. You're not a journalist to make the world a better place. You're a journalist to tell us what the fuck happened.
Right.
So, it's just a question of moving the Overton window of the entire culture over. It's a monumental task. It's probably never going to happen, but it's a dream, and it's a good one to pursue. You have a limited amount of time in your life to do something good. Do something good. Get the word out. Red pill some more people. Help the people who need help, and fight the fight.
Right.
Is it going to work? We don't know. But one thing's for sure, you don't fight the fight, you lose.
I would agree.
So,
well, I think that'll be the last question. So thank you. We are at 2 hours. MGTOW Esquire, is there anything that you would like to close the stream on?
No, that was awesome. It was a lot of fun. If I have any, well, I don't know if you're going to do the pimp's prayer.
I think I'll avoid it. I probably would if I had it up, but I'm a little bit too tired. It's been a long few days. Yeah.
I tell you what, I love that TFM stream. Pimp's prayer is awesome.
That was
right.
That's fantastic. So
thank you very much. This was a lot of fun. This was very fun.
I always enjoy talking with you, and we always have a lot of really good questions in the audience when you show up. So thank you, everybody, for checking us out. I know we had kind of a double feature today, so the stream was a little bit long for those people who were able to stick around for both. Thank you. Thank you again, MGTOW Esquire, for taking the time out. And
absolutely. Thank you for inviting me.
Absolutely. And Lily, thank you for being a good Q&A thought and letting us know that you don't choke. I think that's important. So
I think it's very important.
All right. All right, guys.
Sorry for the question we didn't get to.
That's okay. It happens. All right, guys. You have a great day. Take care.
Bye.
Bye-bye.